I am Crista Haynes, the owner of the Haynes Law Firm in Redlands, California. Today on our episode, we are going to be discussing what this channel is going to offer to you and our subscribers. The Haynes Law Firm Legal channel is bringing to you legal knowledge in the areas of family law, which will include divorces, annullities, legal separations, child custody and visitation matters, support matters in the area of spousal support, child support, as well as property division, including retirements. We will also be talking about paternity actions, as well as adoptions and surrogacy petitions. We will also touch on occasionally your prenuptial agreements, as well as post-nuptial agreements. The Haynes Law Firm also offers services, and therefore this podcast will endeavor to explore juvenile dependency matters. Juvenile dependency matter is the formal name for a case involving CFS, which is the Children and Family Services Department under the Department of Social Services, which is more commonly known as CPS. We will help those going through these types of cases understand how the law, both case law and statutes, as well as rules of courts, play out and affect each individual's cases throughout the legal proceedings and court cases. We'll also be discussing the areas of guardianships and conservatorships, as well as estate planning that you can do prior to involving yourself in court to hopefully keep yourself out of probate court. This channel is a place for people to ask questions, to gain legal knowledge, and to understand how factual situations play out in a court of law, in family law arenas, or the probate court in areas of guardianships and conservatorships, so that people can understand how their personal facts and how their stories are going to play out and be affected by statutes, as well as case law. Each and every year, the Supreme Court of California, as well as the Supreme Court of the United States, decides cases that have ramifications for those individuals fighting those individual family cases in the area of divorces, paternities, and the like. Most people don't take the time to spend countless hours reading case briefs and or learning the changes in the law. This channel is going to do all of that for you. You can utilize this channel to help you do the research that you wouldn't otherwise have the time to do. I'm going to take the time to break down important statutes and code sections under the Family Code of California, as well as the cases being determined by the appellate court and above that have significant changes to the law that can affect your cases. I'm going to discuss what the data separation means. I'm going to discuss what discovery is. I'm going to discuss what the atros are and what that means for your case when you file a summons and petition. I'm going to explain that atros are the automatic temporary restraining orders that are put into place the moment you file that petition for child custody, for divorce, for legal separation, or paternity. People often file these documents and fail to ever read the second page of the summons. Here, today, and moving forward, I'm going to teach you those tiny little things that can make huge changes in your case and give you the winning edge. I'm also going to be discussing the cases that come down each and every month from the higher courts that change laws that have been consistent in the past, but now are going to be analyzed differently. Knowing these cases and these changes can help you argue your own cases, help you write stronger declarations, help you understand the court system as a whole when you are being represented by an attorney or represented by myself. I am trying to bring the legal knowledge to everyone's doorstep so that they can feel more prepared when walking into court and hearing the judge make rulings in their case, or when a judge asks you for a question, knowing the law that is going to help back in your answer so that you're actually answering the question proposed rather than just responding in an emotional fashion. I'm going to break down each one of the cases so that you can understand how it actually can be interpreted for a divorce proceeding or a child custody proceeding. so that you don't have to question how the legalese is written in a case brief. I'm going to break it down into small nuggets so that it's easily digestible. If this is something that interests you, I urge you to subscribe to this channel and come back each and every time to gain additional knowledge. Gain additional knowledge in the area of divorce. Are you currently going through a divorce and don't understand how the process works? You have a generalized understanding that the process should take 6 months, but don't recognize that that 6 months is actually the minimum amount of time that a divorce can take in the state of California. It is the mandatory waiting period, or rather known as the cooling off period, before a judge can grant you a judgment of dissolution. Once you file your summons and petition, there are several things that have to occur within that 6 months in order for you to be deemed divorced. At the Haynes Law Firm and on this channel, we're going to educate you that it isn't just simply filing the petition, waiting the 6 months, and then getting your judgment in the mail. You have to actively participate in your case. You have to do your preliminary declarations of disclosure and file proof that you have served them on the other side, and either have the respondent do their response or file what is called a request to enter default in order for you to have a default judgment, a stipulated judgment, or judgment after trial. The area of divorce isn't as simply as filing the petition and magically having it granted. You have to work the process, and this channel will teach you how to do that. And if you have additional questions, you can call me at the Haynes Law Firm. We will also discuss the areas of custody and visitation and how there are black letter laws with regards to making decisions that involve children. In the state of California, there's a best interest rule. That means that a judge has to take into consideration your facts and analyze the situation based on the best interests of the children. This is a figment of everyone's imagination, and there is no black letter law or case law that's going to specifically state what this best interest definition is. That means that you have to analyze thousands of cases to understand what types of formulas as well as specific facts of your individualized case need to be focused on in order to persuade the judge that you are arguing that your position is in the best interest of the kids, taking into consideration which parent is going to ensure that both parents have a relationship with the children, that a parent is focusing on the educational needs and extracurricular desires of the children, where a children's health, safety, and general welfare are going to be placed above and beyond that of each parent, as well as other individualized adults in their parents' lives. These are the things that case law analyzes, and this is what specifically this channel is going to teach you about. I'm going to do all of the reading and all of the research and bring you small bits of nuggets of information that you can utilize to write your declaration to make them stronger so that you can have a better case when you walk into court. We are also going to analyze cases dealing with support. Support is a wide array of case law and code sections that determine whether or not child support and spousal support should be given in each individualized case. In the area of support, there are a lot of overlapping cases that deal with both child and spousal support. However, there are micro differences between child and spousal support that this channel will deeply dive into so that you can understand when dealing with income available for support, whether or not it's going to apply in the realm of child support as well as spousal support, or one or the other. I'm also going to express to the subscribers and viewers of this channel what it means to calculate a guideline support number and how that guideline only applies to child support in the state of California, and how a judge cannot determine spousal support by simply putting numbers into a calculator and therefore pumping out a number. Judges in the state of California are precluded from doing so. In fact, that they must look to the California Family Law Code 4320 and analyze each one of the factors listed under that statute. In a episode to come, I will discuss how 4320 is analyzed and what each one of those individualized factors means and how to argue each individualized factor to your greatest benefit. Also in the realm of family law, this channel will discuss in depth the quickly moving and changing area of domestic violence restraining orders, including civil harassment restraining orders and elderly abuse protection orders. In those three realms, I will be discussing in future episodes what it means to be able to qualify for a restraining order in those three realms, what the standard of proof is in a domestic violence restraining order by preponderance of the evidence, which is more likely than not, or the equivalent of 51%, versus a civil harassment restraining order, which has a significantly higher standard of proof. You can't simply file a civil harassment restraining order and rely upon the lower standard to grant it. This channel will go into the ins and outs of how to be able to prove each one of the elements in the restraining order realm, as well as the standard that's applicable. We will also be going through the area of adoptions and surrogacy contracts. This is a growing field in the state of California, and the law is ever changing. I will be reading the ever-changing laws and cases that surround this area and bringing to you the new requirements for adoptions as well as surrogacy contracts. This is equally important for people who are having sperm donors, egg donors, as well as known donors, so that you can adequately protect yourself in the life of your new bundle of joy. We will also be discussing prenups and postnups. These are extremely important when you are deciding to get married or you have post-marriage agreements with your spouse that fall outside of the realm of the California community property statutes. California is a community property state, which is different and separate from the vast majority of other states in the United States. So if you are new to California, this channel will also teach you what separate property and community property means in the state of California, and when moving here, how your assets, debts, and the like can be affected. And more importantly, because this is a realm where so many individuals out there have nowhere to turn to get information, I will be offering a in-depth understanding and deep dive into the realm of juvenile dependency, aka your CPS cases. This is an extremely scary realm if you find yourself being investigated or having your children detained. And I want this channel to be a wealth of knowledge for you so that you can understand what a detention hearing is and what the standard of proof is at a detention hearing versus the standard of proof at a jurisdiction and disposition hearing. This channel, along with the Haynes Law Firm, will help you understand each step, what a case plan is, what the standard is, and how to be able to effectively work your case plan to have a successful reunification with your children. The Welfare and Institutions Code is a wealth of knowledge, but it is also a wealth of knowledge that people do not find themselves very accustomed to or acquainted with. This channel will have a deep dive in what the standards are and how to successfully reunify with your children and bring them back into your care and custody. And last but not least, I will be diving into the area of estate planning, guardianships, and conservatorships, which all fall under the heading of probate. A conservatorship is needed if an adult over the age of 18 does not have the capacity to be able to make decisions on their own, and they need someone to step in to make the decisions for their person or their estate. Conservatorship of the person allows for the conservator to assist the conservatee in making day-to-day decisions where they will live, to attend their medical appointments with them, to have individualized information about someone's health, their medical care, and their necessary medications. However, this channel will also dive deep into the differences between a probate conservatorship as well as an LPS conservatorship, which exists for individuals with mental health needs. With regards to guardianships, these are the same type of cases that I just discussed with conservators. However, these are for minors. Minors do not have their parents in their lives, or their parents have been deemed unfit, or the concerned individual thinks that the parents are unfit, and they need to have a legal mechanism by which to be able to have the child in their care and custody, as well as to make legal decisions on their behalf, such as educational decisions, medical decisions, and being able to move freely about with that child and to travel with that child. And secondarily, moving back to the conservatorship realm, the conservatorship of the estate is the conservatorship portion that will allow individuals to make decisions regarding a conservatee's financial affairs, such as paying bills on their behalf, receiving Social Security payments on their behalf, or managing their estate if they have a large estate that needs to be invested or protected against creditors. The conservatorship of the estate is the appropriate petition to file if you know an adult that does not have the capacity to make those decisions on their own, and they need someone to assist them. And last but not least, I'm going to also discuss on this channel, as well as be able to answer any questions at the Haynes Law Firm with regards to estate plans. Estate plans include wills, trusts, advanced healthcare directives, power of attorneys, as well as HIPAA authorizations. A will is the mechanism by which an individual lays out and describes how they want their assets to be divided upon their death. A will not keep an individual out of probate court, however, which is why it's extremely important to be educated in this area so that you can adequately protect your assets, as well as ensure that the assets go to the right beneficiary, and most importantly, keep your estate out of the probate realm upon your death in order to be able to preserve the most assets, as well as to ensure that your beneficiaries get the assets that you choose. And the way to do that is to endeavor and take on what is called a trust. A trust is established and funded by existing assets during your life to be able to have a will dictate and tell that trust how the trust should be administered upon your death. And so a will and trust work together to keep an individual's estate out of probate court, and assigns a trustee to be able to effectuate the trustor or the grantor's wishes upon their death. It is essential for people to know the difference, because not having a trust established and funded will still have your estate end up in probate court. I will be teaching people what it means to fund your estate plan so that you don't find yourself upon your death and your beneficiaries scrambling to get things done when you have lost capacity, or have your loved ones end up in probate court having to pay exorbitant fees just because your trust wasn't funded. I will be explaining the difference between a power of attorney, an advanced healthcare directive, as well as a HIPAA authorization, so that people can understand that a power of attorney doesn't give someone authorization to have an individualized medical records, because HIPAA still applies. That a person who has an advanced healthcare directive and can make medical decisions doesn't automatically have access to a person's medical history, which is important when making those decisions. And so I will be going through each one of those in depth so that they can be created as well as used effectively, and so that there are no hiccups in the long run. This channel will endeavor to do all of the hard work and to take away the stress of understanding your legal predicament within the areas of family law, juvenile dependency, aka CPS cases, guardianships, conservatorships, as well as estate planning, so that you can make educated decisions about your own life, understand how your individualized facts can be used to your benefit and to minimize any of the negative facts that apply to you personally in your case. Or in the instance of rebuttable presumptions, I'm going to be able to teach individuals that may find themselves in a predicament that is not so great currently, and how to turn your facts into a benefit in the future, so long as you follow the case plans that we're going to be discussing in the future in the realms of juvenile dependency, domestic violence restraining orders, and past criminal convictions when it comes to the areas of child custody and visitation, as well as spousal support. So if this interests you, I urge you to follow the Haynes Law Firm channel and subscribe so that you can get this personalized legal knowledge directly from me to you.